Hello, I'm Dominic Walker, JMW's Inside Man. Suzanne Staunton is a regular on the Inside Man and is a partner and barrister at our London office. Hello, Suzanne.
Hi, Dominic.
So the Secretary of State for Health, Matt Hancock, has resigned recently following, well, a clinch or a kiss in an office with a co-worker. So you're the obvious person to speak to about that with your expertise in employment law. I mean, more generally, in sort of taking Matt Hancock out of it in a general workplace, it must be a tricky situation for any employer to deal with.
Oh, absolutely. I think workplace affairs are extremely tricky to navigate. I think that's particularly the case when you've got someone who's far more senior than the other party. And I think arising out of that comes a number of different issues. So the first is, if you've got a disparity of power, you may find that a more junior person may feel coerced to enter into a romantic relationship with that more senior person, even where that more senior person is unwittingly exerting that power. And that can obviously lead to sexual harassment claims, both against the more senior person and also the employer. The other point is, if you've got a more junior person in a romantic relationship with someone more senior, and they're then treated favorably, and that could be completely unrelated to the fact they're having this affair with this more senior person, that can lead to other employees sometimes unfairly alleging nepotism. And so you may find then that both the disgruntled employees and those in the relationship could bring a grievance and potentially an employment tribunal claim, saying that there's been unlawful treatment. So it is a massive minefield.
So how do employers manage a similar situation?
I think it all comes down to education in the first instance. Employees need to understand what is acceptable behaviour, and they should be trained on workplace relationships, discrimination and harassment. And that training needs to be meaningful and it has to be up to date. And also it must be conducted regularly. And by that, I mean at least every 6 months. So that's the very first step. I think once the workforce is educated, the other thing that employers can look at are perhaps drafting policies to deal with workplace affairs. So by way of example, there are many institutions that oblige their employees to notify the employer of the relationship at the earliest reasonable opportunity, just to allow an employer to steer the situation appropriately. Doesn't mean that they're not permitted to have the relationship. It just gives the employer an opportunity to make sure that everything's dealt with appropriately. And likewise, they should also look at their bullying, discrimination and sexual harassment policies, because of course, all of that feeds in potentially to workplace relationships. And those policies should be circulated and they should be publicised well. And so if an employee does allegedly breach that policy, employers then need to conduct a fair and impartial investigation, and they then need to take all necessary steps against the employee if any or all of the allegations are upheld. So taking that approach means that hopefully the employer has taken all reasonable steps to prevent harassment or discriminatory behaviour, and then the employer can utilise that as a complete defence to any discrimination or sexual harassment claim in the employment tribunal.
You mentioned policies and handbooks, and of course you can assist with all of that, as well as providing advice as well to any employers in a similar situation. If you'd like to contact Suzanne, you can insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.